Okay, live breaking news in the Fani WIllis case. Trump has responded to Fani WIllis's response that the cell phone data, this gets confusing, is irrelevant. So he's responding to the response to the cell phone data. Let's jump right into it. This is huge. Okay, in case you missed my last video, so I talked in depth about, go check that out. I'll leave it in the end screen, or just go check out my YouTube channel or Rumble. I talked in depth about Fani WIllis saying that all of the phone records were irrelevant and did not show any evidentiary proof that her and Nathan Wade were anywhere in close ties, that the pings, came from a multiple radius where businesses, etc., which none of the businesses were open at those hours. And so she denied everything, basically, essentially. So just today, Trump has now responded. And this is his response. He just filed this literally today, February 25th, 2024. And this is what it states here. So the state protests that the defense is somehow not entitled to present expert testimony regarding the cell site location information, as they allege that the defense failed to comply with the court's standing discovery order that mandates prior notice to the opposing party of a party's intention to introduce expert testimony. And because they claim that defense has not pre-cleared the evidence through the process of Dalbar hearing, however, neither of these preconditions apply here. So basically, just really quickly, Trump's side, his attorneys are saying that the state is saying that we can't, none of this is admissible because we didn't give a pre-cleared order or pre-cleared evidence through the process. But what they're saying is their rebuke to that is, however, this is the key here, neither of those preconditions apply here because the CSLI information that the defense intends to introduce, that's the data, through the testimony of Middlestott, that's the investigator, is not being offered through expert testimony. He, will not be offering any opinion testimony. We'll be summarizing the data produced by AT&T to the lawfully issued subpoena, as well as factual information that he acquired regarding cell site locations. So he's basically what Trump's side is basically saying is that, you guys are saying that this is inadmissible. We're not saying that this guy is an expert, because through the actual process and protocol, you have to always release information that these are our expert witnesses. You have to give this to each side way ahead of time in order for it to be admissible. Now, I'm not a legal expert. This is not legal kind of expertise, but this is just what I know. These are all personal opinions. This is just my reaction to this. I'm sharing this with you, and by all means, don't take this for black and white, as in this is ironclad truth. If there's any legal experts out there, any lawyers out there, I'm getting this from Phil Holloway, who just posted this. Phil Holloway is an attorney. And so please, by all means, if you are an attorney or a lawyer, please comment below. I'd love to hear your comments on this. So that's basically what this kind of response entails. On page 9, there's something really interesting on page 9 that I think is really, really important. So it just kind of goes through all of the different sort of presentations and arguments that, hey, we're not saying he's an expert. This is just what we subpoenaed through legal means. Okay. Now, this is interesting on page 9. Okay. The interesting point here on page 9 is the state's last ditch effort. This is really, really interesting, and I want to share this with you. Okay, so I want to zoom in on this because this footnote here by Trump's response and his response team says listen to this. This is really, really a brutal footnote here. He says right here, the state's last-ditch claim on page 9 of its response. Let me take off the highlight so it reads a little bit better there. The state's read this with me. I'm gonna share this with you. The state's last-ditch claim on page 9 of its response that the defense obtained the cell phone records at issue illegally is patently frivolous. The records were obtained by valid subpoena issued to AT&T. As the state hopefully knows, defense counsel cannot apply for a search warrant, and a subpoena does not require probable cause to be issued. So the reason that I'm calling this brutal, the reason I'm calling this really, really interesting is because this basically invalidates everything Fani WIllis, everything that her lawyers are trying to say, that none of this is irrelevant and none of this is admissible because this individual, this investigator, Mittelstadt, or however you say his name, I apologize if I'm saying his name right, they're saying that this guy cannot offer expert testimony because he didn't go through essentially the proper protocol and processes of legal precedents. And this footnote really kind of is a rebuke to that. It's a retort that says, no. It's really interesting that the phrasing, the language, the state's last-ditch claim. I mean, this is really, really interesting here. Tell me what you guys think. Let me know in the comments. What do you guys think of what's happening here so far? Whose response? Do you think Trump's response is strong? Do you think it's valid? I would love to hear what you guys say in the comments. Here's even more. There is clear authority, this second paragraph, that cell tower evidence linking a particular phone with a particular cell tower at a particular time can be established through cell phone records without any witness testifying. In United States versus Sanchez, in the 11th Circuit approved the use of the business records exception to admit cell phone tower records that documented the tower nearest to the cell phone when a phone call was placed by that phone, as well as the number that was called. The government was permitted to later call, a detective to testify only as a summary witness regarding what the records show. Okay, then it even goes on even more. Okay, this is so interesting. I mean, the response from Trump really, really is interesting. So check this out. Here, Mittelstadt used Cellhawk instead of Celebrite. His testimony will mirror the testimony offered in Georgia courts and courts throughout the country when one uses a cell phone, either by texting or calling, receiving a call, or by simply having the cell phone on so that it is constantly pinging. A cell tower nearby will receive and record the ping. This evidence simply shows the approximate location of the cell phones based on the nearby cell towers. He will offer no opinion. He will not testify as an expert, but only as a summary witness explaining exactly what the records show. The prosecution will surely point out that nobody knows what was happening in the house between midnight and 3:28 a.m. on September 12th, or between midnight and 5 a.m. on November 30th. Mittelstadt does not claim to know, neither does President Trump claim, or any other defendant in this case. Only two people know. They are certainly the ones who should testify and say, this is so interesting, the language here. Only two people know. They are certainly the ones who should testify and say exactly what was happening on those occasions, so nobody will complain about improper speculation or improper efforts to distort the truth or nefarious contacts with the media. All we have heard from Wade and District Attorney Willis so far has been that they did not have a romantic relationship until 2022. Yet it is highly significant that the state's response did not even attempt to challenge the CSLI evidence regarding September 11th through 12th, 2021, or November 29th through 30th, 2021. The defendant's business record CSLI evidence is admissible, and Mittelstadt stands ready to testify as reflected in his affidavit. So amazing. So absolutely amazing. And here's another brutal footnote. I mean, these are These are really, really interesting, these footnotes here. The state's response also fails to factor in that the more extensive data for the two dates, including the CellHawk-generated animated map, which details every cell tower hit along the route of travel, demonstrates Wade's phone traveling to and remaining at the Dogwood address, which is the condo. That's amazing. That is amazing. Wow. Nor does the state choose to inform the court that this is the same data that Fulton County District Attorney's Office routinely relies upon to obtain convictions, and thus any suggestion that this data is unreliable is disingenuous at best. So this is what we were talking about yesterday. This is what we were talking about yesterday specifically. Nor does the state choose to inform the court that this is the same data. So basically what Trump's response is these guys use this technology to prosecute all of their convictions. I mean, not all of them, but any conviction that requires this type of data. So for them to say it's unreliable, that it does not supply any evidentiary basis, is just flat out, I mean, they're saying disingenuous. It's a big giant capital B to the big giant capital S. It's a bunch of BS. Fani, you're cooked. Saute some onions, saute some green peppers, because your butt, Fani, is cooked. Either party is entitled to offer evidence that contradicts the testimonies of a witness. The witness in this case, both Wade and Willis, testified that the romantic relationship did not begin until March or April of 2022, and that they had never spent the night together prior to the spring of 2022. The evidence offered by the defense to refute this testimony, the CSLI, is admissible pursuant to Code 2466-621. Basically, what they're saying is Nathan Wade and Fani Willis lied through their teeth, okay? And these CSLI records, which is basically the phone data, okay, let's move on here. The impeaching testimony may simply reveal that the witness's version of events is less likely to be true. So this is really, really amazing. The CSLI, in short, the impeachment CSLI evidence can be introduced simply by offering the CSLI records. Again, that's the data, the cell phone data, that demonstrated that Willis and Wade spent 2 nights together on dates that contradicted their version of events concerning the inception of their romantic relationship, and in contrast to their testimony that they never spent the night together at the Hapville condominium. Wow. Wow, this is absolutely huge. I will paste a copy of this entire report, this entire file, in the description of this and show notes of the video and podcast. So make sure you check out this. You could probably Google it, or just go to my Twitter, and I will repost. I will repost this whole thing on my Twitter if you want to go check it out there. Holy macadamia nut. Here we go. Here's the last part I want to just share. Given the testimony of Wade and Willis that they never spent the night together, the evidence, actual record evidence, not just an opinion or speculation, that proves that while talking on the phone with District Attorney Willis, Wade drove from near his house to a location near her condo, if not exactly to her condo, at midnight, where he then remained for 5 hours. Not once, but twice in 2 months, qualifies as relevant evidence, if not presumptive proof, of the fact that they did spend the night together on those 2 occasions at the Hapville condominium. And then here's the direct kind of statement that Nathan Wade and Fani Willis lied. The cell phone records that show they were talking on the phone and then ended up at the location near or at her condominium for 5 hours makes more than just one fact likely than not. 1, they spent the night together on those 2 occasions, and 2, their romance began before Wade was hired. One more fact is also more likely true than not. Neither of them testified truthfully at the hearing on February 15th. Respectfully submitted. Wherefore, President Trump respectfully requests that the court rule the evidence as admissible, permit the defense to call Middlestadt as a witness to testify, and about the records and his use of the software as reflected in his affidavit. Respectfully submitted, Stephen H. Sadow, Jennifer L. Little. Those are Trump's attorneys. Holy macadamian nut. As I said before, I will link the entire document, okay, to the show notes and the description of this video. It's posted on my Twitter at Professor Nez if you want to go check that out. Holy macadamia nut. I was not planning on producing this video today, but this is just a bombshell, absolutely live breaking news. Basically, they're putting in writing that Fani Wade. See, oh my God, I just did a Freudian slip. I just pulled the Jim Jordan. Fani Willis and Nathan Wade. She should be Fani Wade at this point. The Fani Wade debacle, let's state. Their response to the cell phone data being irrelevant was just responded to by Trump's side, Trump's attorney, saying, hey, no. This is admissible. And they bring up very, I think, substantive cases and legal, this is why you hire good lawyers. They bring up legal precedents. They bring up the actual factual data that supports and evidence that supports that this should be admissible because it's relevant. It's highly relevant. But I want to turn this over to you guys. Holy macadamia nut. What do you guys think? Do you guys think that this evidence should be admissible? Do you think it's inadmissible? Do you think it's irrelevant? Because it doesn't directly say, hey, Nathan Wade was at her house for this amount of... it has heat maps. You ask my opinion, he was there, and he was there all night long, as Lionel Richie used to say. But I want to hear from you. What do you guys think? Let's dive straight into the comments. Again, I want to have a thriving, enthralling, engaging debate and discourse, thoughtfulness, respect above all, insightfulness. I don't want any personal attacks, ad hominems. I will not respond. I want my comment section to be the best comment section on any video, any podcast, any content online, period. You guys can do this by helping me out, by just being respectful. Let's do this. If you missed the video yesterday, check out the video over here coming up on the screen. If you missed the video that I did yesterday to Fani, when I went in depth with Fani Willis's response to the data, go check that out. As always, if you made it this far, make sure you subscribe to our free newsletter, free in the pinned comment. Subscribe and follow. May God bless you. May God bless the United States. Oh my God, more to come. I'll see you guys soon, very soon.